Welcome and thank you for joining us for today's episode, where we'll be unpacking the key distinctions between share block schemes and sectional title ownership. This session is designed to provide valuable insights and deepen your understanding of these two property models.
Please note that the information shared in this podcast is intended for educational purposes only and does not constitute legal or financial advice. We encourage you to consult with a qualified property professional for guidance tailored to your specific circumstances. With that said, let's dive in, and we'd love to hear from you. Leave your questions and comments so we can explore these topics further in upcoming episodes.
So you're thinking about buying property, maybe an apartment, maybe a townhouse, and suddenly it feels like you need a law degree.
Oh, absolutely. You get hit with all these terms.
Exactly.
Yeah.
Like sectional title or share block.
Yeah.
And your brain just sort of fogs over with all of the jargon. They can feel pretty overwhelming.
It really can. And, understanding what you're actually signing up for, the ownership structure itself, it's fundamental.
Yeah.
These aren't just fancy labels. They really dictate your rights, your responsibilities, even practical things like getting finance or how the place is run.
That's exactly the maze we want to help navigate today. For this deep dive, we've looked at quite a few sources: expert opinions, legal articles, government info to try and cut through that confusion.
Mm-hmm.
Our mission really is to demystify sectional title and share block, pull out the key differences, help you understand what really matters about these ways of holding property in shared buildings. So where should we start?
All right. Let's begin with share block schemes. They sort of predate the modern system in many ways. They were quite common back in the 1950s, even before specific laws, though they were eventually regulated by the Share Blocks Control Act in 1980.
Right, the Share Blocks Control Act. So if I buy into one of these, what do I actually get? Do I own my apartment?
And that's the absolute crucial point to grasp right from the start. With a share block, you don't own a piece of the building or the land itself.
No.
No, instead there's a company, and that company owns the entire building and the land it sits on. What you buy are shares in that company.
Shares. Like stock market shares. That feels really different from buying a house.
It is fundamentally different. You're a shareholder in the company that owns the actual property, the immovable asset.
Okay.
And linked to those shares you buy, you get a specific right. It's usually set out in something called a use agreement. That agreement gives you the right to, use and live in a particular part of the building, say apartment 10B, or maybe parking bay number 5.
So the company holds the main title deed for everything. And my ownership is really just shares that let me use my specific bit. I don't technically own the walls and floor around me.
That's precisely it. No direct ownership of the bricks and mortar. The title deed stays with the company. What you hold is movable property, the shares, which gives you the right to occupy part of an immovable property owned by someone else, the company.
Wow, okay. That distinction feels huge. What does that mean in practice? What are the sort of real-world consequences?
Well, probably the biggest one, and often a major headache with share blocks, is getting finance.
Mortgages.
Exactly.
Yeah.
Because you don't own immovable property with a title deed that a bank can register a bond against. Getting a standard home loan is very difficult, sometimes impossible.
Right.
Banks just don't like lending large amounts against shares as security. It's not as safe for them as having a bond over actual property. You might get a personal loan, maybe, but that's a whole different scenario than a mortgage.
Yeah, access to finance is critical for most buyers. That's a massive difference. What about managing the building day to day? How does that work?
Management typically falls to the company's directors. They operate under the Share Blocks Act and the Companies Act. They make the decisions about budgets, maintenance, running the place.
And the shareholders, me in this scenario.
Well, you have shareholder rights under company law, of course. But generally, the directors manage the scheme day to day without needing to consult shareholders on every single thing. Your control is much less direct than in, say, a sectional title scheme.
Okay, interesting. So share block recap.
Mm-hmm.
Shares give usage rights. Company owns the property. Directors manage. Financing is tough. Got it. Now, let's switch gears to sectional title. That's the one most people encounter now, isn't it?
Yes, definitely the dominant model today. And it's governed by its own specific laws. Started with an act back in 71, then a major update with the Sectional Titles Act of 1986, and more recently, the Sectional Title Schemes Management Act, the STSM Act from 2011, which focuses heavily on the management side.
Okay, different laws. So what's ownership like here? What am I actually buying?
Right, this is the core difference. With sectional title, you buy and you own a unit, and crucially, that unit is legally considered immovable property.
Immovable property. So I get a title deed.
Yes. You get a title deed registered in your name at the deeds office for your specific unit. That's the game changer.
Okay, so I own the property,
Yeah.
but what exactly is this unit? It's not just the empty space inside my flat, is it?
No, definitely not just the air. A unit legally consists of two parts that are tied together. First, there's your section.
Bisection.
Yeah, that's the bit you own exclusively. Your apartment, maybe a garage if it's defined as a section, a townhouse unit. The boundaries are usually defined by the median lines, the sort of halfway point of the walls, floors, and ceilings.
Median line, so half the thickness of the wall between me and my neighbor belongs to me.
Pretty much, yes, up to the center line. And the second component of your unit is an undivided share in the common property.
Undivided share in common property.
Mm.
What counts as common property?
That's basically everything else in the scheme that isn't part of someone's section but is used by or benefits multiple owners or is part of the main structure. Like the land the building sits on, the foundations, the outside walls, the roofs, stairwells, lifts, corridors, driveways, gardens, swimming pools, boundary fences, all that shared stuff.
And is this all clearly defined somewhere? How do you know what's what?
Absolutely. There is a critical legal document called the Sectional Plan. It has to be approved by the Surveyor General. This plan shows very precisely the boundaries of every section, the boundaries of the common property, and it also identifies any exclusive use areas. It's the blueprint for ownership and responsibilities.
You mentioned exclusive use areas. I think I know these, like that specific parking day only I can use, or maybe a little garden patch outside my ground floor unit.
Exactly. Exclusive use areas, or EUAs, are technically parts of the common property, but the rights to use them exclusively are given to one or more specific owners. So legally it's common ground, but practically only you get to use it.
How are those rights official?
Two main ways, really. They can be formally registered as a real right against your unit's title deed. That's done under Section 27 of the old Act, and it's a very strong right that passes automatically to future owners.
Okay.
Or the right can be granted through the scheme's rules under the newer STSM Act. This creates more of a personal right between you, the body corporate, and other owners. It works, but it's not registered directly on the title deed itself.
Right, registered seems more solid.
Yeah.
Now, the million-dollar question. If it's common property but only I use it, who pays to maintain my exclusive use garden or parking spot?
Yes, the cost question. It trips people up. Generally, the body corporate is responsible for arranging the maintenance of all common property, including EUAs.
Okay, so they organize it.
But the rules almost always say that the owner who benefits from that exclusive use has to pay an additional contribution to cover the costs associated specifically with that area. So things like a share of rates or insurance related to that space, and definitely the direct maintenance costs, mowing that patch of lawn, fixing the paving in that parking day. Your standard levy covers the general common property. The EUA costs are usually an extra charge on top, unless the rules specifically say something different, which is rare.
Good to know. Exclusive use often means exclusive cost.
Yeah.
Okay, what about the overall management? How does sectional title compare to the director-led share block model?
It's another fundamental difference. When you buy a sectional title unit, you automatically become a member of the body corporate.
The body corporate.
Yes, that's the legal entity that governs the scheme, and it's made up of all the owners. As a member, you have a direct say. You attend general meetings like the AGM, you vote on budgets, rules, major projects.
So owners are directly involved.
Very much so. And the owners elect trustees, usually fellow owners, to handle the day-to-day management decisions, but the trustees operate under the direction and restrictions set by the owners in general meetings.
Much more democratic, it sounds like. You also mentioned something earlier, participation quota, PQ. What's that about?
Yes, the PQ. Hugely important in sectional title. Every single section in the scheme is assigned a participation quota, and it's shown right there on the sectional plan.
Okay, and what does this PQ number actually do?
It determines three really critical things for each owner. One, your percentage share of ownership in the common property. Two, the value or weight of your vote when votes are counted by value rather than just one owner, one vote. And three, your share of the scheme's expenses, the levies you pay, and also your share of liability if the body corporate gets a judgment debt against it.
Wow, okay, so it affects ownership, voting power, and costs. How do they decide on the PQ number for each unit? Is it just random?
Oh no, not random at all. For residential schemes, the standard way is based on the floor area of your section compared to the total floor area of all sections combined.
So bigger apartment, bigger PQ.
Generally, yes. A larger section usually means a higher PQ. And an interesting point from the sources is that those exclusive use areas we talked about, They don't count towards your section's floor area for calculating the PQ
Why not?
because they remain legally common property even if you have the exclusive right to use them. So the PQ is based purely on the size of your actual section.
Okay, so my PQ directly links to my share of the common stuff, how loud my voice is financially speaking, and how much I pay each month in levies. That really is a key number.
Absolutely. The body corporate uses the total PQs to calculate how much each owner needs to contribute to the admin fund for running costs and the reserve fund, which is for long-term planned maintenance.
Right, got it. Okay, let's try and tie this all together concisely. If someone's trying to get their head around the core difference between share block and sectional title, what are the absolute must-know distinctions?
Okay, let's boil it down. 4 key areas.
Go for it.
1. Ownership. Sectional title. You own a movable property. A unit, you get a title deed. Share block. You own shares, movable property, in a company, giving you a use right.
Property versus shares. Clear. Number 2.
Control and management. Sectional title. Governed by the body corporate where owners or members elect trustees, have direct input. Share block. Managed by company directors, less direct owner control over day-to-day operations.
Owner control versus director control.
Yeah.
3. Financing. Sectional title. Generally much easier to get a mortgage bond because it's registered immovable property. Share block. Difficult to finance, banks are wary of lending against just shares.
Well, that financing point is huge for most people.
Massive. And finally, 4,
Yeah.
what is owned? Sectional title. Your unit is your section, plus an undivided share of common property. Share block. You own shares that grant a right to use a part of the building owned entirely by the company. That really nails down the fundamental split, doesn't it? And looking at those points, especially the financing difficulties and lack of direct ownership in share blocks, it makes perfect sense why so many buildings would want to convert to sectional title.
Really strong, especially after the Sectional Titles Act made it a widely available option.
Is converting straightforward, though? Or is it a bit of a legal headache?
It's definitely not a simple flick of a switch. Our sources emphasize it's a formal, mandatory legal process. It's laid out in the Share Blocks Control Act, actually.
Okay.
And the rules are there not just to make the conversion happen, but also, importantly, to protect the people involved, like the company's creditors and even shareholders who don't want to convert.
Wait, you can be a shareholder and not want to convert. How does the process handle that? What are the steps?
Yeah, it's designed to accommodate that. The sources outline several key stages. First up is the company decision and prep. The share block company itself has to decide to go for it. This can be initiated by the directors, or if enough shareholders push for it, the law says at least 30%. A really crucial early step is getting consent from the bank if the whole property has a mortgage on it. They have to agree. Then the company gets all the documents ready, draft sectional plans, proposed rules for the new body corporate, that sort of thing.
So the company lays the groundwork. Then what?
Then comes shareholder approval. They hold a meeting, and you need pretty strong support to proceed. Usually, it's what's called a special resolution under company law, or alternatively, approval from 50% of the shareholders by number, provided they hold at least 30% of the total voting rights. It needs a clear go-ahead from the owners.
Makes sense, if the company and shareholders agree.
Then there's a really important step, notification and objections. Everyone involved needs to be formally told what's happening. That includes all shareholders, anyone the company owes money to, and this is highlighted as very important, any lessees, meaning tenants renting in the building.
Tenants get notified. Why is that so crucial? Do they have specific rights?
They absolutely do. The law specifically protects tenants during a conversion. Sections 11A and 11B of the Share Blocks Control Act are key here. Residential tenants have to be told about the plan and their rights, such as a right of first refusal to actually buy the unit they're living in. They usually get 90 days to decide if they want to accept an offer from the company to purchase it. And if the premises are rent controlled, that period jumps to a full year, 365 days.
A whole year?
What?
Wow. What if they say no or the time runs out? Can they just be kicked out?
No. If they don't accept the offer, they're protected against eviction or having their rent hiked just because the building is converting. Those protections stick around even after the offer period unless, they break their lease for other reasons like not paying rent or something.
That's really good to know tenants have those protections built in. Okay, so notifications go out, objections are handled. What's next?
Next is the registration stage. Assuming all the legal boxes are ticked, objections resolved, bondholder consents in place, the company applies to the deeds office to formally open the sectional title register for that property. This step, just getting the register opened, can often take about 6 months, sometimes more.
6 months.
Yeah. And here's a key detail. When that register first opens, the share block company is still listed as the owner of all the newly created sectional title units.
Hang on, so even after it officially becomes a sectional title scheme, the original company still owns all the individual flats initially?
That's right, that's the initial state. The final step is the unit transfer. This is where individual shareholders get involved again. They now have the option to ask the company to transfer the title deed for the specific unit they occupy into their own name.
An option. They don't have to take ownership.
Correct. They are not legally forced to take transfer. They could technically remain a shareholder in the company, which now owns sectional title units, though that's pretty unusual. For those who do want to become the registered owner, they need to request the transfer, make sure they've paid any outstanding amounts to the company, cover the conveyancing costs for their specific unit transfer, get their own bank's consent if they're financing it with a new mortgage, and also formally give up any rights they had under the old share block lease agreement. This is the moment their movable shares effectively become ownership of immovable property.
That sounds like quite a multi-stage process. Company level first, then individual owner level. What's a realistic time frame for the whole thing?
Well, the sources suggest that just getting to the point where the sectional title register is open, so the company stuff, approvals, registration, that part often takes between 6 and 12 months. Maybe longer if there are complications. Transferring individual units adds more time after that.
And the cost?
Yeah.
Significant.
Yes, there are definitely costs. The company has costs for lawyers, land surveyors, maybe architects for the plans. But then, crucially, each shareholder wanting to take transfer has to pay their own conveyancing fees for their units transfer. So it's important for individuals to budget for that specific cost.
Okay, so weighing it all up, the time, the costs, the complexity versus the benefits. What are the main pros and cons for an individual owner thinking about converting?
Okay, pros first. The biggest win, as we've said, is you become the registered owner of actual immovable property with your own title deed.
Which means?
Which usually means much easier access to mortgage finance, possibly better interest rates. It also generally translates to a better or at least more stable resale value because sectional title is just so much more widely understood and accepted in the market. Plus, you get that direct say in managing the scheme through the body corporate and any old tax benefits of share blocks are mostly gone now anyway.
Easier finance, better resale value, more control. Those sound like strong positives. What are the downsides or risks?
The main ones are the costs involved both for the company initially and for your individual transfer. There's no guarantee that the immediate jump in property value will cover those costs, although long-term it usually does. And as mentioned, the process itself, especially getting the register open, can be lengthy, easily 6 to 12 months, which requires patience. Some people also argue, though it's subjective, that volunteer trustees might not be as slick or experienced as the old company directors were at managing things, but you can always appoint professional managing agents.
Yeah, that management trade-off is interesting. One last practical thing. Disputes. If things go wrong, neighbor issues, levy arguments, problems with maintenance in either a share block or a sectional title scheme, where do people go? Is there a specific place?
Yes, thankfully there is. It's called the Community Schemes Ombud Service, or CSOS.
CSOS.
Exactly. It's a statutory body set up precisely to handle disputes in community living schemes. And importantly, it covers both sectional title schemes and share block schemes.
Oh, it covers both. That's useful.
Very useful. It offers a much cheaper and often faster alternative to going through the courts. CSOS can deal with all sorts of disputes, money issues, behavior problems, governance complaints, problems with the buildings or common areas, management disagreements. They use conciliation and adjudication, and their orders are legally binding.
That brings us to the end of today's discussion on share block schemes versus sectional title ownership. We hope you found it informative and useful as you navigate the world of property investment and ownership.
Remember, while we aim to provide clarity and insight, this content is for educational purposes only. Be sure to seek personalized guidance from a qualified property specialist for your unique circumstances. Thank you for listening. If you enjoyed this episode, feel free to share it, and don't forget to leave your questions and comments. We're always keen to explore new topics and dive deeper in future episodes. Until next time, stay informed and empowered.